Thank you, folks. We're going to try to move along as best we can and keep with the time limits of these presentations. The next presentation is by a good friend of mine, one of the best lawyers anywhere around, Jeffrey Manishen.
Nice to have a prop to work with. I got to say, at the beginning of the session, I was sitting with two of my colleagues in the world of giant ego, Mr. Edelson and Mr. Skirka, and we're watching the other speakers. And it reminded me of the old joke. The old joke, how many criminal lawyers does it take to turn in a light bulb, screw in a light bulb? And the answer is 5. Why 5? Well, 1 to screw in the bulb, and 4 to go, you know, I can do that a lot better than him. But with this particular play, see why I like the prop? It's like working the room. And you guys can see me, okay? The reason that I also want to comment, I want to thank all the previous speakers for covering everything I was going to say. No, actually, what I want to talk about is my favorite subject, and that is cross-examining, getting maximum impact, not just cross-examining a witness on a prior inconsistent statement, but getting the biggest bang for your buck. And it doesn't necessarily take a ton of creativity. Certainly it takes lots of research and preparation. But there are a couple of principles to keep in mind. I've covered the stuff in the paper, so I can talk extra fast to get more stuff in my 10 minutes. And what I want to emphasize when you're dealing with the exercise of cross-examining a witness on a prior inconsistent statement, keys: form of language, form of precision. And there's no room for wiggle on that. That's what the exercise is all about. So in the context of preparation, which you want to look at, you want to have available, as the previous speakers told you, it's like an information retrieval system. You want to be able to categorize and catalog and quickly find again everything that the witness has said. But for the bigger bang, you get into the circumstances when the witness made the prior statement. Don't stop at what the witness said, but how it came about. Now, in the context of a preliminary inquiry, you have the opportunity to develop the foundation to explore with the witness and others, not only the declarant, but the recipient of the statement, all of the surrounding circumstances under which the witness made the statement. And it is a very handy exercise every time you do a prelim to do something that an estates and trust prof named Peter Hogg, now Dean of Osgood, used to say, we have to trigger the class closing rules. And what are they? Well, they're things like, when you spoke to the police previously, did you tell them everything that you could remember? Was your memory clear at the time? Did the police record accurately what you said? Did you have the opportunity to review and correct afterwards? And did you read that statement over before you signed it? We aren't putting that statement at the prelim. We are putting the circumstances of the taking of the statement. I love this one. Before you went into the interview, you thought about what was going to be happening. You knew that they were going to be investigating a serious matter. You went over in your mind the events that you were going to be telling them about. You determined that you would be as accurate as you could be in the interview process. Through the interview process, you told them the truth. You told them everything you could remember. There was nothing to prevent you from being able to give everything. At the end, they gave you the chance to correct or clarify. They asked you, is there anything else you can remember? And you told them everything you could remember. Isn't that right? And leave it. That's your foundation at the preliminary hearing. We're never going to put the statement to the witness. If at the time of the preliminary hearing, and remember that Crowns may well not take the time to prepare the witness for the prelim as well as they will at trial, great opportunity to anticipate the witness will get off the track, and if they do, let them go. Don't steer them back, because you are looking all the time as you're going through the preliminary hearing to develop the foundation for the impeachment exercise at trial. Spend the time to really lock in all of those features. If we're dealing with statements where you say it's a trial in provincial court where you haven't had the opportunity for a preliminary hearing, early on in the cross, before you even approach the matter of contradiction, do the same kind of exercise. When you know that there may well be some inconsistencies, because you've already heard the evidence in chief, before you get into anything further, early area may well be lock in the circumstances of the taking of the statement, because that's going to set the witness up for later impact at trial or on cross-examination. Obviously, as the evidence is given on examination in chief, you got to listen quickly. You got to have your own system to be able to write quickly. You want to ensure, again, precision and language. You know in the course of preparation you are getting ready to contradict. When you have that evidence come out on examination in chief, the alarm bells go. You look quickly to make sure that you've got the contradiction in the identical language. And if it's not quite identical early on in the cross, get it identical. When you are going to contradict the witness with a prior inconsistent statement, the analogy I always use, it's like putting the witness on the train tracks. It's got to be the exact same train tracks as that statement. Not close to the train tracks, the exact same. So when you put to the witness, so if I have your evidence correct, you say that, boom, and it's the exact contradictory language to the statement. But then let's get more out of it. And what you told us today, clear in your mind, right? You've always remembered it that way, haven't you? That's because the event stood out. When you came to court today, you knew you were going to be asked to tell about the incident. You went over it in your mind. That's the picture that came out. Clear picture, no question about it, right? You're sure. I don't like the, and you're as sure as that as all the rest of your evidence. I never understood what that means, really, but it doesn't get you a lot of impact. You're sure of it? You got it? Right. Okay, let's go back for a sec. You remember the police interviewed you? Yeah. You went into the interview? Yeah. Serious matter? They made notes? Yeah. Prepared a statement? Yeah. Lots of detail, right? Yeah. You decided you would be as accurate as you could? Yeah. You told them what was in your mind at the time, right? Yeah. How? Now we do the litany. You recall that you were asked these questions, give these answers, if it was a preliminary hearing. Or you remember that the police asked you for your statement. You gave them all the details, read it over, signed it. Yes, I'm showing you now the document. And I don't want them to read it at that point. I just want the ID. You can look at your signature at the bottom. We aren't reading it yet, because if they read it, they might be thinking about the potential inconsistency. ID the document or the prior occasion upon which the statement was made. Then, if it was a preliminary hearing, the litany. You recall being asked that question, giving that answer. You've read it out. Yes. The books say, and was that answer true? I don't like that one. For me, better impact is, was that answer the truth? The truth is a lot more substantial than was it true. The truth. True is, yeah, true, but I made a mistake. The truth we can't shake. The truth is etched in stone. If they said it before and it was supposed to be the truth, then what the hell are they saying now? Okay? So then, what we're doing, we're taking that point in the witness's testimony, we're putting up on a velvet cushion with spotlights around it. It is a very big deal. Why? Because we got something to contradict. Maybe in the overall scheme of things, it might not be a big deal. We're going to make it look like a big deal. The exercise is called getting maximum impact. So when we make it a big deal, then we go, gee, funny. Prior occasion, same kind of deal, went through the same story, told us not X versus today as X. Now, you can do all kinds of things. I've given you a couple of ideas with the not X. The time you told the police, not X was clear in your mind, right? Yeah, sure of not X, yeah. Now, today you tell us X, yeah. Do you ever ask why? Scary times. You may well stay away from why. Most of the time you stay away from why. I'll conclude in a minute or two, unless you want me for longer. No, I'll conclude in a minute or two with that, with a why that I did, and it worked out great. But in terms of, well, the way your mind worked when you met with the police is like running a movie, right? Sure, and you're just like everybody's memory. That's the process of memory, isn't it? You think back, you get a picture in your mind. You're running the movie and you're telling the police what's in the movie. Yeah. Today, for this jury, you're running the movie. Yeah. Different pictures. Is that how your mind works? Is we can run the movie a couple different times. We'll get it coming out different ways. Yeah. Okay. I don't need an awful lot more than that. Now, it may be that there'll be intervening circumstances which change it from yesterday's movie to today's, because maybe they realized they made a mistake. Oops. Maybe they realized things didn't fit with what other people say. Maybe somebody's talked to them. Maybe they've thought about it more and remember a lot more. Nah, the stuff they remember more always hurts you more, doesn't it? So what we have to do, we have to certainly bang them around on that. We may want to explore the circumstances under which more seems to have come to light. We may want to suggest to them that they now have additional information which has affected the new recollection, and that's really why. But one case that I did with a police officer, my client said the cop never even told me really that I was under arrest or what I was charged with. I look at his notes. It isn't there. There's no... Told him of arrest in 10A and B. Okay, but of course you know the cop has, I love this line, only in Toronto do you hear it, I had an independent recollection. Hamilton, we don't have independent recollections. We got people that remember it now, but it's not an independent recollection, okay? The cop, he remembers he told the guy who was under arrest. I had fun with this, and my view was I want to make the cop a cowboy. So what I did for impact, I said, so you remember that? Yeah. Well, then you consider it's an important point to note that you told the guy what he was arrested for? No, I didn't. Oh, you did. Just let me get that. I start writing. Do I have that right? I didn't think it was important. He said, well, I had an independent. No. I just want to get your last answer. I didn't think it was important to note if I told him he was under arrest and what for. Is that right, officer? He looks at me and says, I'll give you an A for your acting. Won the case. Asked the why, essentially. Got the answer that kills him. You do it if you're sure, but what's the point of the comment? Impact, impact, impact. You got a gun, shoot it. Thank you, gang.